from the media for this presser and interaction around the subject of Bill 7 of March 2025. The President made a declaration to the effect that the nation had agreed the amendment of the Constitution of the Republic of Zambia. That petition was filed on the 8th of April, 2025. So we moved the full bench of the Constitutional Court to hear the petition on behalf of the petitioners who are seeking reliefs, who are seeking certain reliefs, and challenging the constitutional making process. Okay? So I'm going to read out the reliefs that were being sought by the petitioners. Number 1, a declaration that judgment in the matter of Law Association of Zambia and Chapter 1 Foundation Limited versus Attorney General 2019/CCZ/0013 was entered per incuriam and therefore null and void and of no effect. As the Constitutional Court, that is the view that we hold, that the Constitutional Court has power to determine the constitutionality of a bill or action taken to amend the Constitution. Number 2, a declaration that the decision by the respondent, which is the state, to undertake a constitutional amendment process without undertaking wider consultation with the citizens of the Republic of Zambia, directly or through their chosen representatives, is a breach of Articles 8 and 9 of the Constitution of the Republic of Zambia. An order directing the respondents, which is the state, to undertake wider consultation with the citizens of the Republic of Zambia prior to tabling a constitutional amendment bill. Number 4, an order to stop the Minister of Justice through the respondent to halt or to stop the action or decision until after wider consultation. Number 5, an interpretation of Article 128, Sub-Article 1, Article 3, Sub-Article B, as read with Article 2 of the Constitution of Zambia, if the same limits the jurisdiction of the Constitutional Court to only act or to only act on a statutory instrument. These reliefs that our petitioners were seeking, we hold the view that our Constitutional Court has immense power, and this petition was based on that premise as to whether the Constitutional Court can make an order to stop a process which, in the view of the petitioner, may lead to a document that does not hold the views of the Zambian people. That was the basis of our petition. The Constitutional Court today passed a judgment. They have not given us all the reliefs that we sought, but the reliefs that they've given us, I think, is the most important. It's the most important. So I'll go through what the court said in summary, and then I'll discuss what's the implication of this order. So this is what the court said. After reading the whole judgment, of course we can't go through the whole judgment. Accordingly, we grant the following relief. Actually, it's one that they've given us, but it's the most important. We declare that the decision by the respondent to initiate a constitutional amendment process before undertaking wide consultations with the people goes against the spirit of Articles 1, 2, 5, 7, 8, 9, 51, 90, 91, and 92. That's a challenge for you, the media. Go and read those articles. So in conclusion, the court said, we order that the respondent complies with the spirit of the Constitution by ensuring a people-driven process led by an independent body of experts in conducting wide consultations with the people. So that is the judgment that has been rendered by the Constitutional Court today. And so you have to understand that when the Constitutional Court makes a judgment, that is an apex court. So a judgment of the Constitutional Court becomes law. So I'm aware also that the president, I think, has agreed with our position. I've seen a press statement where he has ordered the Minister of Justice to withdraw the bill from Parliament, which in our view is commendable. This is what we've been fighting for in court for the past few months, and we are glad that we are at this place today. But for stakeholders, okay, for stakeholders who want to participate in this constitutional making process, you want to get hold of this judgment, okay, that empowers you now. When this process starts again, you have this judgment to allow you to be part of the process. So this is where we are now, and it's a victory for the petitioner, yes, but effectively it's a victory for the Zambian people. And it's not a contest where this one has won and this one has lost. No, we can't even say the state has lost, because the petition was about having a process that will give legitimacy to the amendment of the Constitution. So it's a win for everyone, in my view. So stakeholders must get hold of the judgment, and then when the process starts again, we are hoping to see a broad-based consultative process with all stakeholders allowed to give their input. One of the arguments we had in court was around Article 79, which gives legislation in dispute with regard to the legislative power of Parliament. Our contention was that by the time the bill is hitting the floor of Parliament, the contents of that bill should reflect the views of the Zambian people. That has been our contention. And so, if the process is flawed, there's a high risk that the content will also be flawed. So the court has guided. It is our sincere hope that all the players will comply with the directive of the court. And then at the end of the day, we are hoping to have a document that will stand the test of time. I'm sure we'll allow questions at some point, I think for now, that's what I have to say. Maybe the owner of the petition has a comment or so.
Thank you very much, Council, and congratulations for delivering the protection of democracy to the Zambian people. Countrymen and women, the judgment we have today speaks to the fight and the zeal that we have to ensure that democracy is protected. This judgment speaks to the fact that we are here to protect and defend the Constitution of the Republic of Zambia. We're on record indicating to this government that the process they had undertaken was flawed and it did not speak to the aspirations of Zambians. And of course, when we decided to take this matter to court, I know most people thought it was just a mundane exercise. But alas, we've been vindicated. The Constitutional Court has ruled with us and in favor of our petition, indicating that the process that this government undertook was not the correct one because it was not inclusive. My grandfather was not consulted in the village. Your grandfather was not consulted. In Wengwa, the chief there was not consulted. Now what we need to do is to come up with a constitution that will speak to the aspirations of the Zambian people. And not where we've got individuals sitting in cabinet there, taking whatever drink they are taking, and deciding that this is what will give the people of Zambia. No. We spoke against it. We indicated that the constitution has to speak to what the people want. We indicated that if anyone feels there are lacunas in this constitution, they must take those provisions to the Constitutional Court for interpretation. But alas, our colleagues did not listen. They did not listen because today we are faced with a very sophisticated coincidence where a president will decide to withdraw a bill or defy a bill a night before a judgment is read in our favor. What a coincidence. And I will say shame on you, Mr. President, shame on you. Because this coincidence leaves much to be desired. This is a time for this country and this government to undertake what we call a self-introspection. You need to introspect and see the people that surround you if they've been advising you correctly. And today I saw in the morning the Minister of Justice and the Solicitor General trying to justify their incompetence. But all we can say is this judgment speaks to what the Zambian people want. It speaks to the protection and defense of democracy. We thank the Constitutional Court for the magnanimity of coming up with this judgment. That is the true essence of being a lawyer who's sworn in to protect and defend this constitution. And I've placed it on record several times that I shall do so to protect this constitution, even if it meant doing so with my life. Will not allow anyone to vilify this constitution. At least not under my watch. That I shall not do. If anyone in this government will decide to abrogate constitutional provisions at will, they must know that we've got avenues which we shall take, which is the court. All legal means shall be taken to ensure that we protect and defend the constitution. Now, going forward, our hope and aspirations are that this government will respect the judgment of the Constitutional Court. What this simply means is that the so-called Bill 7 will no longer be there. It is dead. It is a foregone issue. What this simply means is that we must go back, if at all this government will still have intentions of amending this constitution, we must go back to the people and consult them. They must go back and conduct what is called a wider consultative process. We told them to say there's a legitimate expectation that has been created by the processes of coming up with a constitution over the years. And that includes coming up with a technical committee through a commission of inquiry instituted by a president to understand where or what provisions we must amend. Not where you just dream and decide to come up with provisions on your own and you want to call them non-contentious. In fact, on that fact, I want to refer to what the court indicated, by the way. On page J24 of the judgment, they said, we have noted the respondent's argument that the proposed amendments relate to non-contentious issues. The court said, we are not convinced. More so as even so-called non-contentious issues can change the Constitution fundamentally. The only way to properly protect the Constitution is to take every amendment process through a wide consultative process with the people at inception. This is what the court is saying, and this is what we've been telling our colleagues. So, colleagues, I think it is important to remind the regime that when voices of reason come to you and tell you things, do not think everyone is politicizing. This was not a political battle, and it must be understood as such. This was not a political battle. This was a battle to fight for our democracy. This was a battle to fight for the Constitution of the Republic of Zambia. Colleagues in the media, the raison d'etre of having a preamble in the Constitution saying, we the people, is what the Constitutional Court has indicated. That we the people give unto ourselves the Constitution. It is not a mundane exercise to have that provision there, no. And apparently, had it been that today the Constitutional Court was not comprised or was not composed, the full bench was not composed for the sole purpose of delivering the judgment, it would have rendered this whole matter an academic exercise, because our colleagues, according to them, in their infinite wisdom, they have deferred the bill. But the reality, colleagues, is that this bill is dead. If they want to come up with any other bill, let them ask us, the Zambian people. We come up with a bill together as one, as the Zambian people, having consulted the Zambian people. Then whatever will come to the floor of the House will no longer be called Bill 7. It shall carry a different nomenclature. And that is the reality. So I wish to thank Council for the spirited fight that we put in this. I know we had sleepless nights studying constitutions of other jurisdictions and how they are amended. Colleagues, you've done a tremendous job for the country. I think you were not representing me alone or my colleague, Honorable Munir Zulu. You were representing the Zambian people. And you were representing the democracy of this nation. Otherwise, we wish to thank you very much. And I don't know if there are any questions.
I have a question, Mutare from Kumiyasu Media. Is there a chance that the president had idea and that this is the outcome, or what could have preempted the whole thing, without mentioning for how long it's going to be?
I think, like I indicated, colleagues.
My name is Andrew from Diamond TV. I want to find out, Council. Don't you think this proves to us, especially you, that at least this judgment proves that there is independence in the operations of three arms of government?
Okay.
My question is with regard to what you're saying, Bill 7 is dead. Because from my understanding is that they've declared it unconstitutional because they did not have a wider consultation with the citizens of Zambia. What happens if the government decides, or the New Dawn government or the UPND administration decides to consult more and then brings it back? Does it mean they can't bring it in the name of Bill 7? Is this what you are contending?
All right, thank you very much. Maybe let me answer the questions first before we take up other questions. It is, like I indicated in my preamble, that the coincidence is too much. It is too much that a day before a day before the judgment could be given to us by the Constitutional Court, the president decides to take a logical decision, a rational decision. For me, I will tell you that that pressure that the president undertook, the decision the president undertook to direct the minister, I will tell you that, if I can use that, Mwakambalet, it has come at a later stage. It's too late. It's too late because the Constitutional Court was already composed. A full bench of the Constitutional Court was composed to deliver a judgment. For me, I would actually say, because of this coincidence, we may have to think, it's an opinion, we may have to think that at some point the president may have had sight of the contents of the judgment, or may have been advised by his Attorney General that, we failed to defend ourselves in that matter, because there were very splendid constitutional lawyers who argued this matter. So on that vein, I hope I've answered. I cannot go any further in answering that. However, the coincidence is too much. I think Mr. Mwansa's question was...
Perhaps if you can just repeat it, Mr.
I wanted to find out whether this proves that there's proper independence in the operations of the arms of government.
Yeah, as to whether it proves whether there is proper independence or not, going back to the coincidence is too much that the executive arm of government would make a decision to withdraw or to defy a bill a day before a judgment is rendered against them. So whether it's, for me, I will tell you that it is extremely important for us to now, going forward, we need to fight for the principles of law that deals with democracy. Complete separation of powers. We must ensure that the courts must be respected to operate independent as they should. The coincidence is too much. That's all I can say. The coincidence is too much. I think any rational or reasonable Zambian can see that the coincidence is too much. But alas, we've got professional men and women at the bench who in turn have refused, should I say, to accept with the government's argument on this process. They have given a voice of reason. And answering the third question, I think let me just refer to this paragraph in the judgment on page J24, paragraph 55, which says, having considered the Constitution as a whole, in particular Article 1, Article 2, 5, 7, 8, 9, 61, 90, 91, 92, and 118, we have come to the inescapable conclusion that the Constitution amendment process cannot be initiated without participation of the people of Zambia through wide consultations. In the absence of evidence, of any evidence that the initial process undertaken by the respondents meets the expectation of wide consultation with the people, as stated above, we are of the firm view that the initiating process lacks legitimacy. It simply means that the process that was initiated to come up with that so-called Bill 7 lacks legitimacy. Therefore, if we have to come up with another bill to deal with the constitutional amendment, we must go and conduct what the court have termed wide consultations. So whatever will be brought before the House will no longer be called Bill 7. Chijachagwa. Bill 7 has fallen. It's a forgone issue. Any other questions?
I have a question. Now, going forward, we are looking at, this is not the end of constitutional amendments in Zambia. We still have more coming. How do you think this ruling will affect or influence the future amendment processes?
I think this has given us some form of closure when it comes to the process of amending a constitution or refining a constitution. This amendment, this judgment has indicated that there is that legitimate expectation as to how the process should be, wide consultation, and a select committee of professionals has to be appointed. So the Constitutional Court has now given us the law with regards to how we should come up with an amendment to the Constitution. So going forward, we now have a process. The same way we were amending it with wider consultations, with having appointed professionals to go out there and asking the Zambian people what it is that they want to be the contents of the Constitution. That is how we will be proceeding. Now, going further, our take has always been that when you feel, or whoever feels that there is a lacuna in that Constitution, it is extremely important that we use the avenue we have to interpret the provisions of the Constitution. Then and only then can we think of amending. If you feel there is a lacuna, go to the Constitutional Court, have the provisions interpreted. Failure to that, you'll be doing a disservice to the Zambian people. The President of the Republic of Zambia is elected on the basis of this Constitution. He saw in to protect and defend the Constitution of the Republic of Zambia. Having introduced a process that does not speak to the provisions of the Constitution of the Republic of Zambia is an abrogation, and it is a breach. What we've been given by this judgment is simply that the President and his government breached the provisions of the Constitution. To me, I will tell you that any rational person having occupied a noble office such as the office of President, with all the nobility that it holds, having breached the Constitution in this manner, must resign on moral grounds. I would actually call for his resignation. If not that, let that minister resign. If not that, the Attorney General has to resign. Because there is a process which we've been given the guidance by the Constitutional Court. So going forward, I think let's increase the level of morality in the leadership of this country. We must sanitize the presidency and the leadership of this country. People must start respecting the Constitution. Unless there are any other questions, thank you very much, colleagues.
Honorable,